Imagine you're sitting across from your financial advisor. He's good, he's calm, he says the words you need to hear. Our system uses machine learning. It analyzes market data, your spending patterns, your risk profile, and it makes decisions faster than any human analyst ever could. This isn't a guess, it's artificial intelligence. You nod, you give him your money. Now imagine this. There was no algorithm, there was no machine learning, there was no artificial intelligence anywhere in the process. There was a website with impressive words on it. There were SEC filings with impressive claims. There was a pitch deck with charts that looked like science. And there was your money. The Securities and Exchange Commission has a name for this now. They call it AI washing. And this video is the story of how it started, how it escalated, and why, if you've ever been sold a financial product with the word AI in the description, you should know exactly what happened to the people who lied to you. I'm your host, and this is the Reckoning Files, where we follow the evidence, follow the money, and find out what institutions hoped you'd never look for. To understand AI washing, you have to understand the atmosphere that created it. Between 2020 and 2024, the phrase artificial intelligence did something unusual in the financial world. It stopped being a description of a technical capability and became a marketing category unto itself. Investment advisors were using it. Portfolio managers were using it. Apps were using it. Public companies were putting it in their SEC filings, in their quarterly reports, in their investor presentations. The word AI was performing a specific function in the market. It was telling investors that this product was modern, sophisticated, and ahead of the competition, and investors responded. They moved money toward anything that claimed the technology. Studies from 2023 showed that companies mentioning AI in earnings calls saw statistically significant stock price bumps. The effect was measurable. The word was worth money. Here's the problem with that. If the word AI is worth money, if just saying it raises your valuation, attracts investors, to lie about it, and some firms did exactly that. The Securities and Exchange Commission had been watching. By 2023, the Division of Enforcement had opened a dedicated initiative around AI disclosure sweep. They were reading the claims, checking the claims, and what they found in certain cases was not artificial intelligence. What they found was a word. The SEC would later write, and this is in their own enforcement documents, that the environment had produced a class of actors who understood that claiming to use AI was valuable regardless of whether the claim was true. In other words, the lie paid off until it didn't. In March 2024, the Securities and Exchange Commission announced something it had never done before. It charged 2 investment advisory firms simultaneously for the same new category of securities fraud. They named the category out loud for the first time in an official enforcement announcement. AI washing. The firms were called Delphia and Global Predictions. And what they had done, when you strip away the jargon, was breathtaking in its simplicity. Let's start with Delphia. Delphia was a Toronto-based investment advisory firm. It was founded in 2018 with a specific pitch. Clients would share their personal spending data, credit card transactions, financial habits, and Delphia's AI would analyze that data to make smarter investment decisions. The idea was elegant. You give us your data, our machine learns from it. Your portfolio benefits. From 2019 to 2023, Delphia put this claim into their SEC filings. They put it in press releases. They put it on their website. The message, consistently and clearly, was, we use artificial intelligence and machine learning that incorporates client data into our investment process. The SEC investigated, and what they found was this. Delphia never used client data with artificial intelligence or machine learning. Not once. Not in any part of the investment process. The data clients shared was not used with any AI system. The machine learning algorithm described in the filings was not functioning in the way described. The pitch, that elegant, plausible, technologically sophisticated pitch, was a fabrication. For 4 years, Delphia collected investor money with a claim that wasn't true. The clients of Delphia, the ones who shared their credit card data and trusted the pitch, had no way of knowing this. They believed their spending patterns were going into a machine that was getting smarter on their behalf. They believed they were early participants in a new kind of finance. They were not. They were simply investors whose trust had been borrowed by a story that wasn't true. Now let's go to San Francisco. Global Predictions was a smaller firm, newer, more aggressive in its marketing. In 2023, the firm made a specific claim on its website and across its social media channels. Here is the exact language the SEC documented. The first regulated AI financial advisor. The first regulated AI financial advisor. That's a category-defining claim. It's the kind of language that positions a company not just as a product, but as a historical milestone. The company that got there first. The SEC also documented global predictions claiming to provide, and I'm quoting directly, expert AI-driven forecasts. Investigators found that these claims were false and misleading in material ways. The firm's AI capabilities were misrepresented. The expert AI-driven forecasts were not what the description implied. Now here's what happened when these cases settled. Delphia and Global Predictions agreed to pay a combined $400,000 in civil penalties. No executives went to prison. No criminal charges were filed. The firms settled with the SEC, accepted the findings, and the cases were closed. $400,000 for investment advisory firms that had been raising client money on false technology claims for multiple years. I'll let you decide how that settlement feels. What is clear from the settlement is this. The cost of lying to your clients about having AI for multiple years was $250,000 for Delphia and $175,000 for Global Predictions. For context, Delphia's parent company had received tens of millions in venture capital funding. The combined fine was a fraction of 1% of what the lie helped them raise. That math matters, because if the penalty is smaller than the benefit, the incentive structure doesn't change. But here's what mattered more than the fine. The SEC had named something. They had looked at this behavior, given it a formal category, AI washing, and put the market on notice. We are watching. We are reading your claims. And if the claims aren't true, we are coming. The question was whether anyone would listen. Some people did not listen. Because while the SEC was processing those first two settlements, another company was doing something bolder. A publicly traded company on the NASDAQ was telling its investors, and the entire market, something that made Delphia's claims look cautious by comparison. The fast food drive-thru is one of the most pressure-tested operational environments in American commerce. Speed is everything. Error is revenue loss. The labor cost is a constant pressure point. So when a company came along and said, "We have solved it with AI," investors paid attention. Presto Automation was a restaurant technology company listed on the NASDAQ. Their flagship product was called Presto Voice, and the pitch was specific. Presto Voice used artificial intelligence to handle drive-thru orders without any human involvement. The AI would listen to the customer, interpret the order, enter it into the system, and complete the transaction. Human labor eliminated. Margin improved. The future arrived. Presto told this story repeatedly. In investor presentations, in press releases, to analysts. The framing was consistent. Presto Voice was an autonomous AI system. Their AI, doing the work that humans used to do. The SEC investigated, and what they found was documented in an enforcement order, released in January 2025. Finding 1. The AI technology powering Presto Voice. The speech recognition, the core processing system, was not Presto's AI. It was owned and operated by a third-party vendor. Presto had licensed it. They had not built it. Every Presto Voice unit deployed in the field was running on someone else's technology, presented as Presto's own. Finding 2. Far from eliminating human operators, the vast majority of drive-thru orders placed through Presto Voice required human intervention to complete. A person, an actual human employee, was involved in processing most orders. The AI wasn't doing what Presto said it was doing, and humans weren't eliminated. They were just moved off-site and out of frame. Think about what this means in concrete terms. A customer pulls up to a drive-thru equipped with Presto Voice. They speak to what they believe is an AI system. Their order is processed. It feels automated. Behind that interaction, there is a person, somewhere, listening, interpreting, completing the order. The AI is a voice. The labor is real. The technology that Presto told the market it owned and operated belongs to someone else. And Presto had told none of this to its investors. The Presto case documented something specific, that labeling a product as AI-powered, even when the core technology was licensed from a third party and required human oversight to function, constituted a material misrepresentation to public market investors. That's a significant legal finding. It means that not just fabricating AI capabilities, but overstating them or misattributing them can constitute securities fraud. This case matters beyond the single company for a specific reason. Delphia and Global Predictions were private investment advisors. Their clients were investors who trusted them with money. The harm, while real, was contained. Presto Automation was publicly traded on the Nasdaq. When a public company makes false statements about its core technology, the harm extends to every shareholder, every analyst, every pension fund or retail investor who made decisions based on those statements. The market is built on the assumption that public companies tell the truth in their disclosures. Presto was charged, it settled, and the SEC sent a signal. AI washing had graduated. It was no longer just a small firm problem. It was a public market problem. The next question was whether it could become a criminal problem. The Department of Justice had been watching. In April 2025, they entered the picture. Albert Saniger had an idea. He believed, or at least claimed to believe, that artificial intelligence could do something remarkable. It could browse the internet, fill in payment forms, navigate security checks, and complete an online purchase completely autonomously, without a human touching it. The app was called Nate. The concept: you find something you want to buy anywhere online. You click once in the Nate app. The AI buys it for you. From 2019 through 2023, Saniger raised money. A lot of money, over $42 million, from investors who believed, based on his representations, that Nate's AI was working as described. Here is what the SEC and DOJ alleged when they filed charges in April 2025. Finding 1. The AI in Nate's app was not performing the purchases. Virtually every order placed by users required manual processing by human contractors. Finding 2. Those contractors were based in the Philippines. Saniger had hired hundreds of workers offshore to complete by hand the transactions that the AI was supposed to handle automatically. Finding 3. Saniger knew this. The DOJ alleged that Saniger was aware the technology was not working as represented to investors, and he raised the $42 million anyway. What the Saniger case added to the legal record was something beyond the question of whether the AI worked. The SEC and DOJ alleged that he had maintained the illusion deliberately, that the human contractors in the Philippines were not a temporary workaround while the real AI was being developed, but a permanent infrastructure designed to simulate a capability that didn't exist. The intent argument is what separates a civil fine from a criminal prosecution. Presto's executives faced civil charges. Saniger faces prison. Let that construct sit for a moment. A venture-backed startup in the United States. A founder pitching the future of autonomous AI commerce. And in the Philippines, hundreds of human workers clicking as fast as they can, filling in payment fields, completing purchases one by one, manually, to maintain the illusion. This is the furthest point of the arc. Delphia overstated the capabilities of a system that didn't quite work as claimed. That's securities fraud. Civil charges, a fine. Presto told the market its technology was proprietary when it wasn't, and autonomous when it wasn't. That's securities fraud. Civil charges, a fine. Nate told investors the AI was working, raised $42 million on that claim, and allegedly knew it wasn't true, while hundreds of hidden workers maintained the illusion in real time. That's securities fraud, and wire fraud, and the DOJ charged it criminally. The Nate case represents the moment AI washing crossed from regulatory enforcement category into federal criminal prosecution territory. The difference between a fine and a prison sentence is typically the presence of something very specific. Intent. Did you know what you were saying was false? Were you deliberate about it? Were the victims real? Was the money real? In the Nate case, the DOJ alleged yes, 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 and $42 million worth of yes. The SEC had named the category. They had fined the advisors. They had charged the public company. And now the Department of Justice had arrived at the logical terminus: criminal prosecution. AI washing in 18 months went from a regulatory warning to a new fraud category to a criminal charge. And here is what I want you to understand before we go to the final act. These 4 cases, Delphia, Global Predictions, Presto Automation, Nate, are not the entire landscape. They are the cases the SEC has publicly announced. The 2025 Seconds examination priorities explicitly stated that the agency was reviewing AI-related representations across registered investment advisors and broker-dealers. Not randomly, systematically. They had expanded the sweep, which means there are more investigations. There may be more charges coming. And the question the SEC and DOJ are implicitly asking every financial firm right now is the same question your clients deserve an answer to. Is the AI real? I want to be precise about something. This story is not an argument that AI in finance is a lie across the board. There are real AI systems doing real work in portfolio management, fraud detection, risk modeling, and automated trading. The technology is real. The legitimate applications exist. This story is about something more specific. It's about what happens when the word is worth more than the thing it describes. When investors are primed to reward the claim, regardless of whether it's true, some people will make the claim. That's not a cynical observation. It's what the SEC found in writing across 4 documented cases in 18 months. So what does a reasonable person do with this? First, ask the question directly. If you are working with an investment advisor, or a financial technology company that claims to use AI, ask them to be specific, not about the word, about the mechanism. What data does your AI model train on? Who built it? Is it proprietary or licensed? What percentage of decisions are made by the algorithm versus a human? These are not hostile questions, they are due diligence questions, and if a firm cannot answer them, or answers them with more marketing language rather than technical specifics, that is information. Second, understand that the SEC whistleblower program exists precisely for situations like this. If you work inside a financial firm and you know that the AI claims being made to clients are false, there is a formal, legally protected process for reporting it. The SEC whistleblower program has paid out over $2 billion in awards since 2012. The program pays between 10 and 30% of sanctions over $1 million. The Delphia and Global Predictions fines were small, but the scale of AI washing cases is growing. The next whistleblower in this space may be looking at something much larger. Third, pay attention to the pattern. In March 2024, the SEC charged 2 private investment advisors, fine $400,000. In January 2025, the SEC charged a public NASDAQ company, fine and settlement. In April 2025, the SEC and DOJ jointly charged an individual founder, criminal prosecution. Each of those cases added a layer. The first established the legal category. The second extended it from private advisory firms to publicly traded companies. The third crossed from civil enforcement into criminal prosecution. If you are reading those cases as an arc, the direction is unmistakable. That escalation is not accidental. That escalation is the government signaling that this is now a serious enforcement priority. The fines get larger, the charges get heavier, and at some point, someone goes to prison for lying about AI. We don't know yet when that happens. We know that the DOJ has now filed criminal charges in this category, and we know that the word AI, powerful, profitable, seductive, has become something that federal prosecutors are now willing to follow into a courtroom. Director of the SEC's Division of Enforcement, Gerber Gruel, said this when the first cases were announced. I want to read it to you, because I think it's the clearest statement of what the SEC believes this is about. As more and more investors consider using AI tools in making their investment decisions or deciding to invest in companies claiming to harness its transformational power, we are committed to protecting them against those engaged in AI washing. Protecting them, that's the word the SEC chose. Not catching, not penalizing, protecting. Because the people on the other side of these pitches, the couple in the conference room, the retiree with the robo-advisor, the ordinary investor who saw the word AI and believed it meant something, they deserve protection from a lie that is dressed up in the language of the future. The AI gold rush created a simple, predictable incentive: lie about the technology and profit from the trust. The SEC named it. The DOJ criminalized it. The reckoning is ongoing. If this video was useful to you, share it with someone who manages money, advises on money, or gives their money to a firm that says the word AI. Because the protection the SEC is talking about starts with knowing what the cases look like. All of the sources for this video are linked in the pinned comment below. Every claim in this script is documented. Every quote is on the record. If you work inside a financial firm and you know that the AI claims being made are false, the SEC whistleblower program is at sec.gov/whistleblower. Next week on The Reckoning Files, a co-founder, a $15 billion company, a federal indictment, and an industrial heat gun being used to swap government export stickers from hollow decoy servers onto contraband AI chips bound for blacklisted buyers. That story publishes Saturday. Subscribe so you don't miss it. I'm your host. This is The Reckoning Files.